Okay, and we're live. Let's hope this whole setup is working here.
We'll soon find out.
Oh my goodness. All right, let's see. Do the sounds work? Yeah, can everybody hear us? Okay, good. Give us some applause. Okay, thank you. Thank you for that glorious applause. Now, fairy twinkle charm sound. Okay, now it's time to turn the page. How about when a miracle happens? There we go, right? And about a drum roll, please. All right, I think we're good. I think we got it. All right, welcome everyone. We are live. I'm Attorney James Betzold, and I'm here with Attorney Gregory Vanderwood, both located here in the great state of Michigan. Greg, tell us a little bit about yourself as we're getting started here.
Sure. So as James said, I'm an attorney here in Holland, Michigan. I do immigration law, a little bit of criminal defense, estate planning as well. I've been working on my own for about 4 years now.
So if you need any estate planning or immigration or criminal defense stuff, Greg's your guy. So don't get in trouble, but if you do, give Greg a call.
That's the key. That's the key. Don't get in trouble, but if you do.
Exactly. You know, when I first started my practice, I had a bunch of lighters because in law school, our law school practice management class professor told us, get some lighters, leave them around at bars and stuff, make sure it says lawyer, your name, and your phone number. And so I did that, and they said, don't drink and drive, don't commit crimes, but if you do, call me. And I got, I think, zero business from those. So. Yeah.
It's a great novelty. I'm sure people enjoyed using the lighters.
I still have some. I still have some in my kitchen drawer at home, so they worked. Well, we were just watching, getting ready for, we were going to just talk about immigration stuff, and then I noticed that we have some news, some breaking news, in fact, some breaking news out of the United States Supreme Court, and it is immigration adjacent. So let's go ahead and just share, what's the button I got to hit here, browser? There we go. So we're going to just share the screen here, and you can see what we're looking at. It looks like the United States Supreme Court curbs injunctions that blocked Trump's birthright citizenship plan. So a little bit of background on that. Oh, I lost my spot here. Here we go. So a little bit of background on that. The Trump administration said, we don't want everybody to have birthright citizenship, even though the 14th Amendment to the United States says they do, just for being born here, right? And they made all sorts of arguments, and then they brought it to a lower court, and they brought it, in fact, how many injunctions were there? Wasn't there something like some ridiculous amount of courts that, oh no, it wasn't just on this issue. It was like multiple issues that the Trump administration has tried. I think since the beginning of the Trump administration, it was something like 54 nationwide injunctions that federal courts have placed on one of their policies or proposed policies. Anyways, they wanted to do away with essentially a constitutional amendment that gives anyone birthright citizenship in the United States. And a lower court said there's no way that's constitutional, so I'm putting an injunction on it, not just in this geographical area, but across the whole United States, which for years has been something that courts have done to protect fundamental rights and constitutional rights of individuals in the United States. And so as I said, we're going to go over this a little bit, but first I want to give a little more context. Now, Greg, I've explained why it might be a good idea, right? Because it protects the fundamental constitutional rights of everybody in the country. Has this ever been abused by a court, though?
Well, I suppose answering that question would be a matter of opinion, but I think fundamentally a district court judge has jurisdiction within their district. And so if they issue an injunction that applies to individuals outside of their district, which a nationwide injunction would be, arguably, whether it's well-intentioned or not, it could be seen to exceed their jurisdictional authority. Now, on the other hand, you would have some inconsistencies if one particular district court judge issued an injunction, another district court judge did not issue an injunction over the same issue. Let's say there were two different plaintiffs in two different states. So I can certainly see arguments for both sides. As to whether it's been abused, I think some could argue that because the power of a district court judge now extends throughout the entire nation, it could encourage forum shopping. Somebody seeking out a particular district court, what they perceive to be a favorable judge, that judge rules in their favor, and now there's a nationwide injunction. So again, I think it's a matter of perspective.
Yeah, well, and forum shopping 100% happens, right? As an advocate for your client, if you have the option, because it's not like you're only going to look across the whole country and file in a place where there's a good judge who would be favorable to your cause. Like, there's rules that govern where you can file a lawsuit, right? You have to do it in a place that would have jurisdiction.
Right.
So either the defendant lives there or operates there, or it's a federal issue, something like that. But it 100% happens. Everybody knows it, but it's not a reason to dismiss a case, right? If there's a nonprofit that says, you know what, immigrants are really suffering, we want to file in the Ninth Circuit because they're generally more favorable, the other side can't say, hey, judge, the only reason they filed here is because they think you're going to rule in their favor. Everybody just says, yes, so what? Go forward with the case. It's not a reason to dismiss a case. It's something that plays in the media and plays in the news and everybody gets all worked up about it. But if they want to dismiss a case because of the forum it's in, they have to find a reason that they should never have been allowed to file there in the first place. And there's rules that govern that. And so what we're seeing today is the Supreme Court essentially saying, I didn't even get a chance to read the whole thing yet, but from the headlines, it sure looks like they're saying, we're going to limit the use of nationwide injunctions, which, I mean, frankly, I listened to the Supreme Court arguments about it. And I know that, yeah, one of the arguments was, there's just a lot of abuse of it that's going on. And I think both sides agreed that it was used. And of course, one side was saying, well, it's used because the president keeps trying to violate the Constitution. And the other side would say, well, yeah, but it was also used in these other cases that were not constitutional or fundamental right issues. And there's no reason that that one federal circuit should get to rule the whole country on this issue.
Well, I think part of it is just the nature of what an injunction is, where, and let's see if I get these requirements correct, but before I give the requirements for an injunction is basically a court is not determining the merits of a particular case. They're just saying, while this case is being decided, we are going to put a particular law on pause. And the requirements in order to issue an injunction are likelihood of success, so if the plaintiff is likely to succeed, and if there is likely to be irreparable harm if an injunction is not issued. And there's a third requirement, and I'm drawing a blank on that, but I think, James, do you know what that third, I think there's a third requirement. There's likelihood of success, irreparable harm. I can't think of the third argument, but
yeah, I don't remember offhand. I'm actually looking at the, let me pull it up here. We'll share the browser.
But I think the key one is irreparable harm.
Yeah. Yeah, irreparable harm, I think, is it 2 or 3? Irreparable harm, likelihood of success on the merits.
Yeah.
And a genuine dispute, maybe? Well, look, in a 6-3 vote, the court granted a request by the Trump administration to narrow the scope of nationwide injunctions imposed by judges so that they apply only to states, groups, and individuals that sued.
That's interesting. That's actually different from what I expected. I have not read the opinion either. So I'm just...
That means the birthright citizenship proposal can likely move forward, at least in part, in the states that challenged it, as well as those that did not. So we're going to need to see every other state's attorney general jump into this, and most of them are elected, or all of them, I think, are elected to office. So I think it's going to depend if they have a R or a D next to their name to see if they want to join the fray on this one. The court was divided on ideological lines, right? No surprise there. When a court concludes that the executive branch has acted unlawfully, the answer is not for the court to exceed its power too. But apparently the answer is to let them go forward with that violation in states that didn't sue. You know, so to me, I don't think Amy Coney Barrett really was trying to be consistent logically here. She indicated that the nationwide injunctions are limited only to the extent that the injunctions are broader than necessary. Well, how do you stop the government from acting if you can't get an injunction against them everywhere?
Well, I think we're seeing the reason why there are classes formed or a class action. So I think the only way that you would guarantee that everyone similarly situated would be a benefit of the injunction would be if there was some kind of a class certified.
So one of the first cases, some of the first few cases I had experience in after finishing law school or during law school, because I did an internship with a firm that did class action lawsuits. And they are a nightmare. Like, a class action is a type of case that can go on 5 years, a decade, without getting any justice for anyone. And if you're dealing with something like whether you're a citizen or not for that long, that has far-reaching consequences. See, in a class action, there's essentially two types, right? If you have a statute that lets you do it, you might be part of a statute in a class action that means you have to opt into it. So if you want your rights under that lawsuit, you actually have to sign a form, you have to read it, you have to hire the attorney who's handling it or a different one to join the case, and you have to proactively take those steps to join the case and to have your rights vindicated. Now there's another kind, the general federal civil class action case, where most of those are opt-out. So everybody by default who could be included is included, and if you don't want to be a part of it, then you have to sign a form to say, I'm not part of this, I'm going to go get my own attorney and we're going to do something different. And there's a whole series of, you got to file the complaint and you got to go through a process called class certification, where you got to show that everybody is pretty much in the same boat. So there's legitimately a group of people with the very same interests who are fighting the same issue and the same law, and they're all going to have like the same harm and the same consequences. And if you think that it would be a shoo-in for something like citizenship or birthright citizenship, you literally have to prove that for a large sample of people, then file a motion, bring it to court, the judge is going to hear it, and the other side gets the chance to pick it apart, piece by piece. And it takes time. And what they will do, and this is sort of fun, right? Or fun to review, not fun for people involved, except the lawyers, is they'll say, well, we see these 5 people, because of their response in these affidavits or their response in this, or to this questionnaire that was sent out, we think that they're outside the scope of what a class would be. So we want to exclude these 5 people. And then we also want to, a little later, they'll file another motion. We want to exclude these 10 people for some other reason, or we want to exclude these 100 people because we don't like how their signatures were taken. Maybe we don't think that their signatures meet the level that it should be. And they'll look for any possible reason that exists to try and exclude people from this class. And when you're in the phase of class certification, their goal is to eliminate or make ineligible everybody who you put into that class, saying, hey, we're a proposed class. So it becomes a fight that takes forever. And attorneys will take these cases sometimes. But the thing is, they've got to be able to run their firms and make money doing other cases and stuff too while this is going on, because they're not getting paid from the government. They're not going to get their attorney's fees and damages until 5, maybe 7, 8, 10 years in the future when the case is actually resolved, if they win, right? These are usually contingency-based cases. So that was actually one of the arguments at the Supreme Court, is they said, well, isn't there a way that they don't need an injunction because you could just file a class action lawsuit? And when I heard that, my brain exploded.
Yeah.
Because it's so onerous to do, and especially when you're dealing with let's just imagine right now, okay? Let's just brainstorm, Greg, you and I, spitballing here. What are some of the issues that could arise in a case where there's a dispute over whether you're a citizen or whether let's say your kid. Let's say one of our kids was born here and we were undocumented at the time, even though now we're citizens, right? What are some of the disputes that could arise if, or complications in someone's life if that happens? One I can think of is, well, do they actually have a right to health care?
Yeah, I think there's a real ripple effect, specifically from an immigration context. If you have somebody who thought they were a U.S. citizen, they file a petition for somebody who becomes a permanent resident, who then becomes a U.S. citizen, who then files a petition. I mean, there's a chain here that's being formed based upon an individual who they believe who is purportedly a U.S. citizen, and if they're not, well, then anybody they ever filed a petition for. But even, I mean, they could have a job that requires a security clearance because they're a U.S. citizen. But I don't know that, and I would need to look at the executive order. I don't think it applies retroactively when Trump issued it.
No, it was like from a certain date forward.
Because otherwise that would be way too complicated. Where then you're going back and you're envisioning, okay, you know, did this person file a petition? Were they a U.S. citizen? But if it's proactive, then certainly, yeah, anybody going forward, kind of in a state of limbo.
Yeah. So I mean, questions, right? If you're not a citizen, well, and the thing is, if they're successful on this, the very next executive order is probably going to say, you know what, same thing, except it goes back 50 years. You could cause some real chaos with that. But let's assume that they don't do that, because you know that could get bogged down in the courts as well, although it seems like they don't really care about that. Yeah, in an immigration context, again, then the question is, well, I petitioned for my spouse. I was told I was a citizen. I have an American birth certificate. I have a U.S. passport. But even on a going forward basis, like, can I go to public schools? Is that going to get challenged now? What about medical care, right? What about, will I be removed from the United States? I mean, I was literally born here. I've never been to this other country. I don't speak the language. I don't know the culture. My parents have papers now. So what about me? Are we going to deport? It's like a reverse anchor baby situation.
Yeah, well, I think certainly there's no question they'd be able to attend schools. I think it's Plyler v. Doe.
Mm-hmm.
But
well, it used to be there was no question that they were U.S. citizens because they were born here.
Well,
it kind of puts everything back on the table, I think.
But I think, where was I going with that? So if somebody, let's say somebody was born here in the United States, they might not be a citizen of any other country if that other country doesn't grant them some form of citizenship.
So they become stateless.
Yes, but there's a UN convention which the U.S. is a signatory to. So that, and again, I haven't brushed up on it, but that could actually be a backdoor way to citizenship if they're truly stateless. Have you seen the 2004 movie The Terminal with Tom Hanks?
I've seen a lot of clips recently
where
on
he's
TikTok
stuck in an airport. He can't be sent back to his home country because I think it was taken over by some new regime, and he's not a citizen of that country.
Wait a minute. There's, I'm remembering now, there's immigration law in the U.S. does deal with statelessness.
Yes, and I don't remember what it says.
Well, there's one provision for what are called, and for if anybody's a Star Wars fan or a Mandalorian fan, they're called foundlings. Right? Are you remembering this?
Yeah.
What, from Star Wars or from immigration law?
From The Mandalorian.
From The Mandalorian, right.
Yes.
So Grogu becomes a foundling because he's essentially stateless, parentless, and he's adopted by Mando, by the Mandalorian, who I think doesn't act, by Din Djarin, right? Okay, so in the U.S. immigration context, a foundling is a child who is found, and I don't know if it's like a child under X number of years or a minor, but someone who's found in the U.S. and we really don't know where they were born or what happened, and they're also like, so therefore purportedly stateless. They can file for adjustment of status, get a green card, and then when they're an adult and have 5 years, become a citizen. I wonder if that would just be another way of getting some sort of status for people who might find themselves in that situation where it's like, oh, I was born here, but now I'm stateless.
Yeah, I think there's also going to be a practical record-keeping aspect where, so it used to be, okay, a birth certificate proved that you were a U.S. citizen, but if a birth certificate alone doesn't prove that you're a U.S. citizen, you would need some kind of additional documentation or proof.
Yes.
And I don't know what that would be. I guess it'd be your...
What federal identification documents do we all have?
I mean, I guess if you had a passport,
everyone's going to have to get a passport when you're like a baby to prove it, I guess. Which we've done, like for our kids, right when they were born. Poor thing, my youngest daughter, she barely could open her eyes because she was born premature.
Oh yeah,
she had such a cute picture. It was like, and that was her passport photo for the first couple of years. But yeah, essentially we're going to have to get passports for all the babies. And then here's the thing. How's the State Department? They're the ones who issue the passports. How are they going to know? They're going to have to know the immigration status of each parent, because they used to not, you didn't need to look at that. It didn't matter where your parents were born. If you were born here, State Department was like, great, show me the birth certificate. Good, you're born here, passport. Now they're going to be like, send your birth certificate, send your parents' birth certificates. I don't know what, send their parents' birth certificates if there's question about that too. Proof of naturalization of your parents if they became a U.S. citizen through the process of naturalization. This was one, okay, and I remember another one of the arguments that that was made at the Supreme Court by those opposed to getting rid of birthright citizenship. So those opposed to Trump, the president in this, they said, look, in every state, there's certain benefits that are only for U.S. citizens. And always the requirement has been you can prove you're a U.S. citizen by your birth certificate, so therefore you qualify for this benefit, that benefit, a driver's license, state Medicaid, state welfare benefits, things like that. Now, to enforce the law properly, how are they going? Everyone's going to have to become a citizenship expert in order to know if they qualify.
I think what you could do is almost have a rebuttable presumption where if somebody presents a birth certificate from any U.S. state or territory, they are presumed to be a U.S. citizen. And anyone who is asserting that they aren't bears the burden of demonstrating that they're not a U.S. citizen, because that way, all you would need is the same documents before a birth certificate. And let's say the government or anybody else had reason to believe that you weren't a U.S. citizen, they would then need to prove that.
Okay, so...
And then they would have to present evidence that your parent, for example,
so like
was not...
you're a citizen, if you have a birth certificate, you're a citizen unless proven guilty. Well, but then what, I mean, if we play this out like a thug, kind of like some of our government leaders love to do, and if you've ever served or volunteered with a homeowners association, you know that this is human nature. The government could just say, well, it's our burden, and you've only shown us a birth certificate, and we suspect, because your last name is Sanchez, that you're not an American. Therefore, we're denying your benefit. And then if you want that benefit from the government, you have to go hire a lawyer, go to probably federal court, because it's a question of federal law, and probably start a class action if you want to include other people in it, but it's going to be prohibitively expensive. So what we're going to see is the tyranny of an administrative state, because all of a sudden you need to prove you're a citizen, but there's no federal citizenship document that's issued at birth.
And I think that's what's unusual about the U.S. Other countries have a national ID. I think that's how you get around that problem.
Well, but the thing is this, Greg, remember, and my conservative growing up background taught me this, we're a republic, which means we're a collection of states, which means those duties of proving citizenship, of proving anything like that actually belongs with the state. It's a state burden. So because we're a collection of states instead of a federation, right? So like Brazil, right, you're going to get a national ID. Colombia, yeah, you know what? Literally every other country in the world, I think, has some sort of a federal ID, where our only version of that is a passport, which would have a photo, or a social security number, which is not by any means secure, has no photo, and they're abused and used all the time, incorrectly, unlawfully, and whatnot.
Well, I guess we got the real ID. That's got to count for something. That's the closest we can get.
Well, but the only way you get a real ID is if you have a passport. And you only get a passport if you can prove citizenship via your birth certificate. Like, we're going to start, I think the next logical step is every state, every hospital, every family is going to have to become an expert on citizenship law so that they can, like, there's going to have to be like a federal birth certificate now, or a real ID version of birth certificates.
I think you're right, the real ID.
If this goes forward. Now, gratefully, this is only on the issue of an injunction, not whether it's like constitutional or not.
Well, I'm curious now, because I know there are many countries that don't have birthright citizenship, and I feel like they would have run into these same issues, and I wonder how they deal with it.
Well, a lot of that's in the context of like refugees, right? Like I think it's Indonesia or Malaysia where they had an influx of refugees from like Vietnam, and then they said, yeah, your kid, you're living in a refugee camp, your kids are born here, but you do not get citizenship here. It's just so far out of let's call it the Western civilization tradition. Because I looked this up, I think it's only like 33 countries out of 250 some that don't have birthright citizenship. So it's definitely the majority position that, yeah, birthright citizenship is a thing ever since like the Roman Empire, right? Which is why you had Paul, right, the Apostle Paul, who could go around, thumb his nose a little bit at the Roman soldiers who arrested him and say, hey, I'm a Roman citizen. And he could go to the Sanhedrin and say, I dare you to touch me. I'm a Roman citizen. If you do that, you're going to be in trouble with the Romans.
Well, I going back to the Roman Empire example, but there were people born in the Roman Empire that weren't Roman citizens. So I don't even know that the Roman Empire had birthright citizenship.
Yeah, you got me on that. I didn't watch enough TikToks on Roman history. Maybe somebody watching here
St.
can comment
Paul,
on that
he
for us.
had it. I don't remember how he got
Maybe
his
it was
Roman.
by birth.
Yeah. So my guess is
Probably it's one of his parents.
one of
was
his
a Roman.
parents, probably. Yeah.
Yeah, that could be. That sounds familiar. Sunday school was a while ago, so.
Well, I mean, if we're getting into the weeds, you have in the Roman Empire, the British Empire, you had the notion of a subject, not a citizen, a British subject.
Yeah, you're subject to the king.
A British subject, and I think there was a different category, whereas in the U.S. it's just a U.S. citizen.
Yeah.
And so then you had the British Empire, you had somebody, let's say, in Jamaica or India who would be a British subject, and I don't know what their rights were compared to a British citizen.
Well, I think from American history, we know their rights were somewhat less
Yeah,
than
I
an
mean,
actual British citizen
Yeah.
living in Britain, right?
Right.
Taxation without representation, for
Yeah,
example, that
yeah.
could happen.
Yeah.
You just had to pay whatever tax the king was going to levy. Of course, we got the 4th of July coming up, and every year we shoot off fireworks to celebrate the fact that we don't agree with that.
Yeah.
And didn't and whatnot. So that's fun. Well, I thought that was a topic worth mentioning. Let's just let's open the browser window here one more time just to take one more look, see if there's anything worth mentioning in here. You know what? And again, a lot of people know that I grew up as I was raised very ultra conservative. You know, it was like Republicans and Ronald Reagan and liberty and freedom and the Gadsden flag and don't tread on me and things like that. And so there is I still sort of have some of that instinct like, yeah, keep the government away from me. But I'll tell you what, I've really warmed up to Justice Sonia Sotomayor. I really like her perspective on things, and so I'm grateful that she was appointed. Let's hear what she had to say. Liberal Justice Sonia Sotomayor read a summary of her dissent from the bench in the courtroom, saying the ruling was a travesty for the rule of law and an open invitation to bypass the Constitution. Federal courts will be hamstrung when it comes, well, that's the end of the quote, right? Federal courts will be hamstrung when it comes to nationwide injunctions, but she urged potential plaintiffs to immediately file class action lawsuits, a legal avenue the court left open. So, Greg, in the context of, let's go back to this, in the context of, I got to think this through. If you file a class action lawsuit instead of just a regular plaintiff lawsuit against the government, you can still request an injunction, right?
Yeah, and I'm thinking,
but it would just be limited to the people in your class.
Limited to that class, and I don't know if
Oh,
this
I
is
just did this. Zoomed in on
it
me.
zoomed you in, but
There we go.
there was a I think this was under Trump's first term when he changed the rules regarding employment authorization for asylum applicants, where I think you had to wait a year rather than 180 days.
Mm-hmm.
And I think there are a few nonprofits, such as CASA of Maryland, who got an injunction, but it was only for members of CASA of Maryland, which was a nonprofit for immigrants in Maryland. So I don't know if that's the same as a class action, or if an organization can basically say, hey, we are seeking this relief and it applies to our members.
Yeah, it can
And
be.
that's sort of an easier way than getting a class certified.
Yeah, so in federal court litigation, one thing that the United States has that's unique that many other countries don't have is, let's say, Greg, let's say that you and I, we are just, do you ever go fishing, Greg?
Yeah.
All right, what kind of fish do you fish for?
I don't know, trout.
Trout? Okay. I got a fun example. I grew up in Petoskey, Michigan, right? And there is an endangered species that lives in some ponds and rivers and areas in Petoskey, and it is called I don't know if it's extinct now, it might be, but at the time, it was called the Petoskey pond snail. Right? So let's say you and I, we are just the biggest Petoskey pond snail fans. We love them, we study them, we just love everything about them. We breed them, right? So we're breeding pond snails. I don't know how you do that, but let's say we do it, and we're just some enthusiasts. And so we say, you know what? We love the Petoskey pond snail so much, we love it so much that we are going to start a nonprofit organization, and its goal is going to be the conservation of the Petoskey pond snail, right? And now let's say that the federal government comes in and they say, you know what? We need to build more bunker buster bombs. And in order to do that, we have to build a factory along the Bear River in Petoskey. And yeah, there's going to be some seepage of, I don't know, let's say depleted uranium. I don't know what they use to build those bombs with, but something like depleted uranium, and it definitely leaks into the water table and it will get into the rivers and things like that. You and I, even though we're not a Petoskey pond snail, because we have a nonprofit whose stated goal is to protect and conserve the Petoskey pond snail, we can file a lawsuit, we can hire a lawyer and file a lawsuit in federal court saying they shouldn't allow the federal government to build a factory along the Bear River because it's going to destroy the Petoskey pond snail, and we are fierce advocates for the Petoskey pond snail. And we can go to court, and then we'll have the arguments, and we can even get an injunction right at the beginning if we say, no, there's irreparable harm. This is the only place the Petoskey pond snail lives, and if it's extinct forever. We're not going to be able to clone them. We're not going to be able to bring them back like the dire wolf for whatever reason. And so that's one thing that's actually unique to the U.S. So that's what we're seeing with immigration. Now, in a case like you were describing, in order to file the suit, yeah, they'll say, well, we're a nonprofit and we're in favor of that. Many times they'll also say, and this is Jose Sanchez, and this is exactly the case he's in, and he's a plaintiff as well. And this other person is a co-plaintiff, and this other person is a co-plaintiff.
Yeah.
So they're all like separate plaintiffs, and one of the plaintiffs is the nonprofit itself, and the other plaintiff can be the individuals or other nonprofits or interested parties. So it's pretty unique to American law in the fact that you can do that. So whenever I'm visiting with friends from outside the country, or usually it's friends from like Cuba, where they're like, wait a minute, you can sue the government?
Yeah.
This is kind of a
sort of an
foreign
odd concept when you really think about
who
it.
lives in a dictatorship for a while. All right, so I think, in a separate dissenting opinion, Justice Ketanji Brown Jackson, another who was quick as a whip at the hearing, she said the decision was an existential threat to the rule of law. And I think she's not wrong about it, because essentially what it says is, yeah, you can stop the government from violating your constitutional rights, but you have to do it in all 12 federal districts, or you have to sign every potential class member as a plaintiff or as a class member into that. And so to vindicate your rights, it's going to happen. Like, imagine living for 5 years with the question over your head, are you a citizen? That means, can you get a job? That means, do you get government-funded preschool, government-funded schooling, okay, regular schooling, I think there's a constitutional right to if they don't challenge it. But things like government-funded daycare, right? Welfare, which if you're a baby to 5 years old, you're included as a citizen when there's women, infants, and children involved, right, with the WIC program. So there could be that question. And then what happens if the state government says, well, we think you're qualified and we're going to give you these funds, but then 5 years later the Supreme Court says, nope, you're actually not a citizen. Then, so let's talk about WIC. We could talk about unemployment benefits, right? Famously, if you're a citizen, you can get them. If you're not a citizen, you don't get them. The government can come back to you and say, hey, you know what? You remember those years ago when we paid you, $60,000 in unemployment benefits or in WIC benefits or whatever. Turns out you weren't actually a citizen, so you got to pay us back now. That's kind of a lousy thing to do, and it's a lousy situation to be in. So we'll see how this one plays out.
Yeah, definitely a lot more to come on this one.
Yeah, and the funny thing is, even as lawyers, I mean, for me listening to the hearing, I was like, oh, yeah, Sotomayor, Ketanji Brown Jackson, I think the liberals on this side of the court probably have the right argument if you're a strict constitutionalist, which all conservatives seem to say that they are, except when it's convenient for them, or except when, they're their figurehead says, hey, I want to do this thing instead. So we got to really, I mean, for people who say, oh, I'm a strict constitutionalist, you better check yourself before you wreck yourself. Let's move on, though. That was fun. Okay, let's talk immigration, because that's really that's our specialty for today. This was a really important Supreme Court decision that just came out. I'll encourage you, share this. If you're watching this, go ahead and share this with your friends. If you want to throw some comments in there, we will be happy to answer them as well, because we're getting into the weeds with immigration now. Now, we usually do these lives in Spanish. There's a lot of Spanish-speaking voices out there already. We're going to be doing, I'm sure, some of this later as well in Spanish. But in English, I think it's important for the world to have context, right? We got to have context about like what is really the law, what should be the law, what's nice to do, what's morally reprehensible to do. And so right now what's happening in the United States is the whole situation about how immigration removal, deportations, immigration court, how arrests by ICE are happening, right? We're sort of in a huge tidal shift of, I mean, procedural and moral values. So let's start with sort of what we've seen. I mean, Greg, we've seen a lot of people, like in California and other places, literally starting riots about how ICE agents are conducting arrests. How is this different than it was under, well, let's just go back to Biden for now. So under Biden, how is it different than arrests were being done then?
I don't know that I can speak to that because
Okay,
I don't know
for example,
what ICE's practices were under Biden. I know the
did
coverage.
they arrest people at immigration court ever before the last couple months?
I have not heard of it. No,
I've never
I've not
seen it
that.
happen.
No, I mean I think what is different. Again, I can't speak to what's happening in Los Angeles, but in terms of the immigration courts, what I have heard is happening is there are people in removal proceedings. Their proceedings are being dismissed by ICE, and then ICE is detaining them in the hallway. And I think what's important to understand is there's really different kinds of removal proceedings. So if somebody has entered the U.S. unlawfully and they've been here for less than 2 years, ICE can remove that individual, deport, same thing.
No court hearing.
Right. If they've been in the U.S. for less than 2 years and if there's no credible fear of returning to their country, they can be removed without a court hearing. Now, if they establish a credible fear, and
that's been the law, let's just say like last 50 years for sure, right?
Certainly since '96, yeah.
And they actually, like the ICE had discretion on how long of a time period, up to 2 years, they could use to say, well, we're just going to deport you right away. Expedited removal, right? So I think under the Biden administration, Obama administration, Trump and Bush administration before that,
it was 2 weeks.
Yeah,
I think it was 2 weeks.
It was really, really short.
And really practically speaking, if somebody was caught close by the border, that is who expedited removal applied to. But the removal proceedings, immigration court or INA 240 proceedings, that would be anybody who's been here over 2 years, or somebody has they have a credible fear of returning, or ICE in their discretion decides to place them in these proceedings. And these are the people who are having their proceedings dismissed and then being arrested by ICE. I assume under the expedited removal authority.
Okay, so category 1, we're talking about individuals who enter the U.S., they're here for less than 2 years, they get caught for whatever reason. Could be a crime they committed, could be nothing. Could be they were just working without documentation, ICE does a raid on a workplace, finds them, they're here for less than 2 years. It's quickly, they're detained and removed, essentially, right? Okay, what's category 2 then? What would be another category?
Category number 2.
Well, let's just say someone who's here for more than 10 years. Or at least 10 years.
Yeah, somebody who's lived for a long time in the United States. That person...
Or more than 2 years, I mean, like 2 to 10 years, something like that we could say, right?
And the reason that removal proceedings would exist for that person is ICE would bear a burden to prove that they should be removed from the United States.
Yeah, so all of a sudden, the burden
shifts.
It's not just, okay, immigrant, you have to show us you've been here for less than 2 years or more than 2 years, right? when someone's between 2 and 2 plus, when they're here for more than 2 or more years, at the court hearing, the government, the very first thing they have to do is they have to prove that this person is and look, I'm going to use the word alien because that's what the statute uses. It's not meant to scare anyone or be intimidating. It's the legal term that's still in use, right? So, and it's how, like if you're going to Google me afterwards and try and fact check me, you're going to see alien all over the place, right? So the government has to prove alienage. The government has to say, hey, yeah, we got their birth certificate, or hey, yeah, they admitted to us, or hey, yeah, we found them with, a Mexican driver's license, a Mexican birth certificate, whatever. It's the government's job. They have a higher burden then to prove that this person is not a citizen of the United States or national, and they have no right to stay here in the U.S., right?
Yeah, and then the burden would shift, assuming it's somebody that didn't enter with a visa, yes, then they would have to prove, okay, either I am a U.S. citizen, or if I'm not a U.S. citizen, I entered on some visa.
Right. And then maybe a third category would be...
I think the third category would be somebody who is a lawful permanent resident or has a visa. And so, because in that scenario, ICE would have the burden of not only proving that you're not a U.S. citizen, but they would have to prove that you are deportable, because that would be under INA 237. So if somebody... So this would be, let's say somebody's a permanent resident, they are accused of having committed a crime, ICE has arrested this individual, ICE would need to prove not only that they're not a U.S. citizen, but also that the crime that they've committed, that they committed the crime, and that it would render them deportable.
Yeah. Now, what was the name of the individual from, was it Columbia University? Green card holder, turns out. He was detained. They were going to try and remove him because he was protesting on behalf of Palestinians.
Yeah, I think he would be in that third category where there's no dispute that he was lawfully admitted, but the government is alleging that he has somehow committed an act that would render him deportable.
Mahmoud Khalil, that's his name, right?
Yeah, right. So that would be I can't think of the
Group 3
section of law but yeah, some section of law.
And
I think it's important to remind people that under the law, if you are a permanent resident, there are certain actions you can take that the government can deport you based on committing those actions.
Mm-hmm. Yeah, that's true. Going back to the category where someone's here for more than 2 years, maybe up to 10 years, all sorts of people in that group, there are people who have, for example, filed an asylum application. They said, hey, I'm being persecuted in my home country. In Venezuela, they jailed me because I was a media reporter and I said something nasty about the supreme leader there. I forget what his name is right now. It skipped my mind. It's not Castro. That was Cuba. It's not Chavez. That was the previous one. It's not Eduardo. That doesn't sound right either.
Maduro?
Maduro, yeah. Yeah, Maduro. All right, so you have those. Now, as immigration attorneys, you and I have both been to immigration court many times in the past under different administrations as well. And when I was first going to immigration court, one thing that I thought was strange, because it was very different than a criminal court, but one thing I thought was a little off was, like when I had a client, we had a hearing, we lost because it wasn't a strong case to begin with. The judge would enter a removal order. Usually, and many times, the client would ask right there, so are they going to take me right now? Right, because in criminal court, if you lose your criminal case, a sheriff will escort you to the jail usually right away. Yeah. Right? And to wait for sentencing because they don't want you running away before sentencing happens. But that never happened. Never saw it happen. Never heard of it happening. And I think we're both, are you still an AILA member?
Not anymore.
We both are or were members of the American
membership
Immigration Lawyers
became a bit
Association.
expensive, yeah. Multiple
Facebook groups for immigration attorneys that have thousands and thousands of members. They'll all tell you as well, it's not happened. Right, so that is something that's actually new now. What they're doing is, if you go and have your final hearing and you lose, ICE will be there to take you into custody. Now, why didn't they do that before, Greg? What do you think?
It's probably a staffing shortage, I imagine.
Well, let's think about like the natural public policy or natural, like, what does it encourage?
Well, and you want to encourage people to appear, obviously, if just like in a criminal proceeding, a respondent, so they're not defendants, they're called respondents in immigration court. they are required to appear for each hearing. If they do not, the government can enter a removal order, or rather the immigration judge can enter a removal order. And so I think it's also a policy perspective, a policy reason, which is we want this individual to show up. If they know that ICE is going to arrest them, they're not going to show up.
Yeah. Let's say, I mean, that is what's happening now. Like, for the longest time, they didn't do it because they said, if we start arresting people at the court, nobody's going to come to court anymore. And I know even under Trump the first time, under Biden, under Obama, the conservatives would say, well, all these people are coming in and they're not going to their court hearings. Statistically, most of them would go because they know there's a chance I can get a work permit. And if they don't do anything, no work permit. And if I got a work permit at least, well, that's something to keep me compliant. And so now, the word on the street among lawyers and immigration judges is the people that were coming to court, out of those people, about 0.5% are actually showing up to court now. So one out of 20.
Wow.
And that's the experience relayed to me by attorneys in conversation with immigration judges in Detroit, Michigan. Okay, so they know ICE is there, they know that they're deporting them, and so they're not even going to show up to court now. So that's going to be more complicated for immigration enforcement now because they got to go out into communities and do dragnets and go door-to-door knocking like a Mormon missionary or a door-to-door salesman in order to find these people. And I mean, it's going to be more dangerous for them. But they sort of shot themselves in the foot on this one because they're arresting people right at immigration court. And they're not just doing that. So they're not just waiting for a final hearing where you lose, right? And for context, those hearings are scheduled, like they might do 1 or 2 a day of those type of hearings. Wouldn't be very efficient to just remove one person because of that. Now there's other days, calendar hearing days, scheduling days, where the judge might have 20 people in the morning where it's just a quick check-in. Hey, how's your case? Did you file it? Do we need another hearing? Do we need an extension? What's the next thing we should be doing? Or do we just finalize your hearing at a future date now? Do we set you for an individual hearing? There's those days. You might do 20 of those in the morning, 20 of those in the afternoon, 40 people altogether. So have you heard what ICE is doing now when it comes to that?
Yeah, well, it's kind of unusual because ICE is dismissing the charges, dismissing the hearing, which ordinarily would be a good thing, right? Yeah. Because in a criminal case, if your charges are dismissed, that is a good thing. But what is happening is ICE is dismissing the case in removal proceedings and then is relying upon expedited removal to then arrest that respondent after they have left that courtroom. So the respondent is in the courtroom. The ICE attorney, you can think of them as the prosecutor. They have dismissed the charge. The respondent, who at that point is no longer a respondent, they go into the hallway and then they are arrested by ICE.
They're just undocumented.
They're just
plain, simple, undocumented.
Somebody out there in the
no
community
visa.
at that point.
So ICE grabs them, they go into detention, and on expedited removal, I mean, it's not like you get to restart the immigration court case. There's no judge hearing then. There's no bond hearing. It's just a matter of, do we have a passport or birth certificate, or does your country or some other third country, maybe somewhere in Africa, maybe we'll send all the Venezuelans to Sudan, maybe we'll send all the Cubans to Malaysia, whoever's kissing the ring of the current president or administration who says, yeah, we'll agree to take your deportees.
Well, I think there is there is a credible fear component because on that sheet, I can't think of the form number, where somebody is subject to expedited removal, there's that box they can check that says, I fear being returned. And so I don't know how ICE is getting around that. Like, let's say somebody was an asylum applicant in removal proceedings, their case is dismissed, ICE arrests them in the hallway, and then the individual says, well, hey, I have a fear of returning to X.
Well, but they had their chance. That's the thing. So,
well, I mean, unless the judge is pre-termitting the application, which I don't know if they're doing that.
Yeah, it's hard to see. We got to actually pull files.
So,
and see what exactly happened.
I don't know.
But the whole point of a credible fear interview is to get you to an asylum case hearing. And if you get to that opportunity and the judge says your whole thing's deficient, see, because the credible fear isn't a factual determination, really. not
True.
not when it comes to eligibility or even potential eligibility. It just says there might be something here. We'll let the judge decide. And when the judge sees it and says, "I'm dismissing it," that's really, I think, whether it's dismissal, pre-termitting, or whatever. It's a decision typically. Typically they'll couch it like it's on the merits. Like,
yeah.
There's no potential.
And there's so many of these issues. Immigration law is so complex. Like I'd honestly have to look up and see what the law actually says.
Yeah, like you and I were talking about before we started here, and I had to grab this just in a question we had about one of our clients who's got an interview coming up. It's like sometimes, and it's so big, and there's so many different areas, right? Like there's removal court, which interacts with USCIS or the affirmative petitions, which interacts with the asylum office of USCIS, which interacts with ICE and their policy memos and their procedures, which can change on a whim based on the president or other direction from the DHS head. So you always have to sort of like war game it out. So like, okay, well, can they get another credible fear interview? No. Well, can they do this? No, because the whole purpose of that is to get to there. You can't do that. It's just, and that's why you need a lawyer in these sort of situations.
Yeah, it's very complicated. I see we have a question here.
Oh, here we go. A person that was deported, entered again, was admitted with a 220A, who wants to apply for withholding of removal, but DHS never docketed, I'm guessing, his case, and now was detained. Well, they entered after deportation, so they are inadmissible for 10 years. They got to stay outside the country for 10 years. We know there's that. He was admitted with a 220A, which is really, that may have been a mistake. They may have said, they may not have seen that there was a prior removal. I don't think you see that very often where you can be admitted even temporarily if you already have a removal order.
Before I start responding to this person, I want to give my own disclaimer. It's not legal advice. Consult with an attorney, obviously,
Yeah.
but...
and there's not enough information in this quote or
we
in
would
this
we would need
comment here.
some more information here, but it's possible that this individual had a reasonable fear interview. That's the word they use when somebody has a removal order, so they were removed from the United States, they've re-entered, and they have a fear of returning. And that's called a reasonable fear interview. And if this individual was given one, then ICE could place them in withholding only proceedings. I don't know if that happened here, so.
It may have, and withholding only proceedings.
It's very hard to win.
Is there bond? Can you even get a bond?
I think it's only if ICE decides to give you a bond. So it looks like the question says, and now is detained, so it looks like ICE is exercising their discretion.
So they may have said originally, yeah, we'll let you go on your own recognizance, or yeah, pay a bond, but they can revoke it.
Yeah.
And they don't need to come up with a reason that they revoke it either.
Yeah, I mean,
and 220A is parole, and we know that they've been revoking paroles left and right. Anyone CHNV, right? Cuba, Haiti, Nicaragua, Venezuela, those all got revoked just like last week, and the Supreme Court said, yeah, we're not going to interfere with the president's ability to do that either. So a lot of people now are getting that letter in the mail saying, you had parole, we revoked it, somebody sued us, the Supreme Court finally came down on our side saying we can go ahead and keep revoking it. So your work permit based on that is now invalid. Please mail it back to this address. And we had some clients who had questions about that this week too.
Yeah, so certainly speak to a lawyer specifically about that one, because I don't know exactly what's going on there.
If they didn't give him an opportunity for withholding and he's in withholding proceedings, you may need a federal case for a habeas petition, where the federal court can say, hey, government, you got to show why you're holding this guy now. And they could just turn around and say, well, we're holding him because he's undocumented.
Or because if he does have a removal order, which it looks like he...
Yeah, and with the removal order, they could just...
And that's
enforce it.
You know, I think some people don't realize that if you have been ordered removed, and then you re-enter the United States, the government can rely upon that previous removal order and say, hey, we found you removable in this date. We don't need to prove it again. So the removal order doesn't magically go away, and that might be what's going on here.
That could be.
Don't know though.
All right, so that was a great question, Carolina. Thank you for that. Here we got one. We got another one here. We're not going to post these on the actual screen here just for privacy purposes, right? I'm sure ICE is not watching, but geez, who knows? There's AI now out there, and they're using all sorts of stuff. What if a person was deported, then returned, and just got married? could this person apply? And if he applies, could that put him at risk for removal? Oh, they're getting deported for sure. Again.
Yeah, so I think that would be the permanent bar, if I'm not mistaken here,
Yes.
the so-called permanent bar.
Yeah, what is
which
that? 212A to A2
9C?
9C
Yeah, so
2A1 or something like that.
This basically says that if you have been living unlawfully in the United States for more than a year, or you were removed and then re-entered, you are barred from, I would say, pretty much any kind of immigration relief. And in order to apply for a waiver, you would need to depart the United States and be outside the United States for more than 10 years.
More than 10 years.
Yeah, so there's a few exceptions there, but just looking at the question as it's asked, could this person apply, and if he applies, would that put him at risk of removal? Well, I guess he could apply, but potentially, is it going to be approved? Doesn't look like it, unless it's one of those exceptions. Would it put him at risk of removal? Absolutely. But with the permanent bar, you always want to make sure you're analyzing it correctly. So
Yeah, and that
you
one...
want to speak to an attorney to see specifically in your scenario whether that would be whether that would apply.
85. That's, sorry, page 96. 212A9C. That's where you find it in the
212A9C,
law.
okay.
So that's the permanent bar section.
Yep.
And yeah, I'll tell you, I mean, both Greg and I have done hundreds, thousands, probably tens of thousands of consultations over the years together. And someone who typically falls into this fact pattern, we just usually have to tell them, like, look, let's see if you would qualify for like a U visa or a T visa or something else which would help us get around there. Maybe it's a VAWA case that we could do. But other than that, sorry, there's nothing we can do. We won't take your money. We're not going to do that. And beware of anyone who says that they can help you, because they're lying.
And I think that's an important part. You know, whenever a client or potential client comes to meet with me, I won't tell them what they want to hear. I will tell them the truth.
Yeah.
And you know, you want to be careful, because if you're speaking with multiple attorneys getting second opinions, while that is a very good thing, if somebody is telling you something, hey, you qualify for this, make sure they're not just telling you because you want to hear it and because they want to get your money. So
yeah, and if you've seen, and I know we're doing this all in English language here today, because we've done many of these warnings in Spanish to the Latino community, to the Spanish-speaking community out there. But there's no shortage of attorneys or immigration professionals out there on TikTok, on Facebook, on YouTube, on everywhere, saying, call me, we can definitely win your case. And then you call them and they're like, well, did your kids ever beat you? Did your kids ever treat you badly? Are they over 18? Are they over 21? Do they still live with you? And you're like, no, that's never happened. Love my kids, they're good. Well, you need to say that they did so we can get you this case and win you. Let's just be clear, Greg. That's a felony.
yeah, absolutely.
It's a felony for the attorney.
Yep.
It's a felony for the client.
Yep.
Everybody ends up going to jail in those situations eventually.
Yeah.
But in the meantime, that attorney or immigration professional is charging you $15,000, $20,000, and they're enjoying life for now.
Yep.
But the problem is it's dishonest. So you have those things to deal with, of course, as well. And it's unfortunate that even some of those in the legal community are engaging in that sort of over-promising, and it's technically fraud if you're
Right.
strong-arming someone into making a false statement on an immigration form and you're signing your name to it. That's a danger. I'll tell you, there was an attorney, Greg, in Detroit. I won't name him because I can't remember his name. I remember what he looked like, though. Had a ponytail. And he had a sweet little deal set up where he was getting a lot of people U visas because he had a buddy in the Detroit Police Department who would sign U visa certifications literally for anything. And everybody was getting paid. Cop was getting paid. The attorney was getting paid. Eventually, USCIS did a statistical analysis and said, hey, on average, attorneys are filing like these many U visas, and this guy's like filing this many way up here.
Yeah.
Maybe we should investigate. And they did, and sure enough, he went to jail. Went to prison for it. Not worth it.
No.
So, yeah. That's a long way of answering a short question. Be careful of anyone who's promising or over-promising you on something like that. We got another question here. I'll read it. How about you
Sure.
take a stab at it? What if a person was deported? No, we already did that one, right? Deported, got married. Could they apply?
So it looks like there is a new one though.
Oh, okay. if someone was returned to their country and fingerprinted in 2000 and then re-entered undocumented, are those fingerprints still in the system or are they removed after a certain time?
They are still in the system.
They are there for.
They will be in there forever.
Even till after they're dead. Now, I appreciate the question. What worries me though, and it just says YouTube user here, so YouTube user. What worries me about your question is this. That's the kind of question somebody will ask if they're thinking about lying to the government. And what do we tell people when they're thinking about lying to the government, Greg?
Well, one, never do it because it's lying, and two, the government knows.
Yeah. And many times, if the client insists on taking that course of action, what are the two very famous words we say that our very famous orange president is famous for? Well, he's famous for a lot of things now.
You're fired?
You're fired.
Okay.
We can't represent you. We're fired, service denied. Sorry, we cannot ethically consult with you or help you forward something that is a fraud. We can't help you we can't help you participate in that using our law license as cover, for example. So now, many people ask it, right? It's not, I don't mean to cast dispersions on your honor or anything, but it is important to know. Yeah, no, you don't need to put your name, don't worry about it. We're just having a good time here. But it is important to know so that when people do ask that to us, that's what we tell them. Look, it's dishonest, first of all, so Jesus ain't going to be happy about it. Two, it's against the law, so the government's not going to be happy about it. Three, it's unethical, so even if you don't believe in God and you're an atheist, it's still not right to do that. And lastly, it's not going to work. So it's just not going to work at all. Now, a totally legitimate question is, can I get a copy of it? Greg, can I get a copy of my fingerprints?
Absolutely. It's called a FOIA, Freedom of Information Act. You can request that from the government, from USCIS, and they will actually give you your complete A file, your complete file. And so that is often a recommended option, which is to just get a FOIA and see what has been filed. Maybe you don't have a copy of your application. Maybe you lost it, you filed it, your attorney doesn't have a copy, or you did it yourself. It's always good to do a FOIA and just find out what's in your file.
Yeah, and there's multiple places to get a FOIA from. You could send it to USCIS to get copies of your application. You could send a FOIA to Border Patrol to get it from them, although they're not always totally thorough in their results. So one thing we recommend is come to our office. We have a fingerprint scanner. We pay every year maintenance fee for that thing in a service so that we can submit your fingerprints to the FBI. You don't have to go to the police department and tell them, hey, I'm undocumented, I'd like to get a copy of my records, and then end up in jail. You come to your lawyer's office, we scan your fingerprints, we submit that to the FBI, we can submit that to the OBIM, which is the Office, what's it stand for? Office Bureau of Information Management.
Yep.
Official Bureau of Information Management?
Something like that.
Yeah. Bureau of Identity Management? Something like that. It's a federal office that does that. Okay, yeah, so FBI fingerprint check is excellent. Even when CBP fails, the FBI is there, and they have that. And that won't just catch like entries to the US, it'll also catch any time you've been fingerprinted by law enforcement in the United States. We recommend it. Nobody I know has gotten deported because they filed it or had ICE show up at their office. So it's very safe, strategically wise as well.
Well, James, I think we might be at an hour here.
Looks like that's time for us. I know Maria, Gavina, what do we think of what was ruled on today? Might be sort of a mixed bag. It all depends on who's in power, right? If we need a national injunction and now we can't get it, that's a problem. We really addressed that at the beginning of the live.
Yeah, I'd say watch the beginning.
Yeah, once we finish up here,
that.
Feel free to just click on that link and do that. All right, we got to answer every question as they come in before we hang. So we're going to hang up real quick, but let's see here. Lawyer, how long does it take to receive the results? I have requested them since November. Okay, a FOIA these days sometimes is taking like a year. You might have to sue the government to get it sooner. To get a FBI background check back, I think those are between 6 and 8 weeks. So there's your answer. All right, thank you for joining us today. Again, this is Attorney James Betzold with Attorney Gregory Vanderwood. We are immigration experts. We live it, we breathe it every day. Also, if you need any estate planning help or if you find yourself needing criminal defense help, give Greg a call here at the law office of Gregory Vanderwood here in Holland, Michigan, and we'd love to help you. So hope you guys have a great day. Take care, and please share this with your friends because there's a lot of important context, and this one's in English. So enjoy. Have a great day.
Take care.